Dear students, so welcome back to Industrial Property HOE 6065. And well, we were talking about licensing of trademarks last time, and a lot of the information is in Moodle. So today I'm planning to just wrap up licensing and then talk about infringement and passing off. And then we are done. Yeah, trademarks is over, done in that sense. And then we can start with patents next time. So let's see. Trademark homework one is still up. Yeah, you have about 3 weeks to go. So I hope you do a good job with that. And the exam dates have been finalized. I'm sorry I couldn't make everybody happy, but yeah, that's how things tend to become sometimes. But this will be an online exam, open book exam, and hopefully, everybody will be able to do it in a stress-free manner. So we were talking about licensing last time, and I just wanted to say, besides what's in the notes, that licensing and franchising sort of go hand in hand very often, and the franchise model and how it works, right? So you're, let's say you're McDonald's, you are in the US, and you have a good thing going. So now you would like to open up other stores in other countries now, or your Hesburger from Finland. Now, well, of course, you could always send some Americans to Estonia and set up a company and restaurant business and everything in Estonia. But that seems a bit too radical, right? Or from Hesburger in Finland, you can go to India or Brazil or somewhere. But that would mean that as a Finnish national, you would now have to know Brazilian laws, Indian laws, and all sorts of stuff. And maybe that's not a smart way to do business. And that's where franchising comes in. So if you look at the notes, there is this McDonald's franchise costs. And basically, what it implies is that McDonald's or Hesburger or Subway or whoever, yeah, maybe even Starbucks. I'm not sure. What they need to do is they want somebody who has a lot of money, and so what McDonald's will do is give them know-how, training, license out their trademarks, explain to them the concept, how this should be, the layout, how, when a customer comes, whether it's in McDonald's Hong Kong or McDonald's New York or McDonald's Tallinn or McDonald's Helsinki or McDonald's Berlin, that there's a certain way to greet and there should be the signage and this sort of stuff everywhere. And as a customer, you should not feel that you are in a different McDonald's restaurant. All the restaurants should be quite similar, and the experience should be similar, and the menu should be similar. Although in some countries, then maybe you try to focus more on other things. Like for example, in India, they tend to focus more on the vegetarian dishes or chicken. Um, and then in the Middle East, maybe non-pork dishes and things like that. And so, of course, what would McDonald's say? The main company in the US now, of course, this is pre-COVID, yeah, may not work nowadays as such. But generally, McDonald's would say that as a restaurant, you can make up to 2.53 million dollars a year. That's guaranteed in a way because all tourists and locals, everybody goes there. So what they want is that you should have liquid assets. Yeah, in this case, almost three-fourth of $1 million. Yeah, 750,000, and you should also have a rented place or your own place, and it should have a certain amount of square meters area. Location is important. It should not be in some dumpy part. It should be in some nice places and certain other things. And so McDonald's gives you everything on a platter, and in return you have to invest your money in a local country, get employees and take care of the legal parts, and of course you have to pay certain franchising fees, and then also you have to pay for the IP that you use. And McDonald's gives you all the training, all the material, all the equipment. Sometimes, yeah. Now, of course, the bread will not fly in from Kentucky, or the chicken won't come in from Chicago or somewhere. It's all locally sourced, but then McDonald's gives you training about how the chefs should work and what should be the usual way to make things and stuff. So the way it would work is, let's say if a hamburger or a chicken burger costs €5, 2.5 already goes to McDonald's USA. That's their share. So, as the local franchisee in Estonia or in Finland, you have 2.5 euros to make your profit. Now, of course, there would be input costs, bread, chicken, yeah, all those things, electricity, employee costs, and everything. So let's say basically it costs maybe €2 to make that burger, and so you have the price of €5. Yeah, this is just rough, tentative. 2.5 already goes to the US, €2 goes in making the burger, and so your profit is 50 cents. Now, of course, if you sell a million such burgers every year, so that's almost what, 25, two, sorry, a million, so that would be €500,000. Yeah. Now, of course, plus and minus, and there are certain additions and things. So, what are the problem areas that can come up over here? Quality control. All right. As a franchisee, I may wonder, should chicken burger only contain chicken, or could it contain some other meat also? Horse meat can be very cheap. And if you put enough spices or whatever, sauce, ketchup, nobody will know the difference. So of course, that's how all these scandals come about. So let's say we have a party, a cheap party, coronavirus restrictions get over, so we all get together and we go to McDonald's in Viru Gates, and then we all order food and we all eat over there, and now you fall sick. Now, you're not going to say, oh, the Estonian franchisee and the Indian cook working there messed up things. You're going to say McDonald's USA messed up. So, of course, licensing and franchising always has this issue with quality control that you have to be careful about. And that's the same even with Subway. If you may know, there are some scandals that come out. So, a Subway foot long is supposed to be 30 centimeters, yeah, 12 inches. And then somebody actually went with a ruler and it turned out it was 11 inches or 10.5 inches. Now you may say, what's the big deal about that? Of course, when you bake food or you warm the bread, maybe it shrinks a little. But you see, you're paying for 30 centimeters, a foot long, and you are getting 28 centimeters. So that's 2 centimeters per customer. If there are 10,000 customers in a week, yeah, you do the maths. All right. So of course, it's a lot of savings that can arise. And so these are sort of problems that come up with franchising or licensing. I've also put up over here in Moodle the checklist for negotiating a license agreement, and what can happen sometimes. So there's also an agreement for assignment of trademarks. These are not for studying though. I'll be marking specifically in Moodle what you should study, so you don't have to study like 10,000 things. I'll mark it all out. All right, so don't worry about that part. But this is basically your entire issue with licensing. And of course, if you have some litigation issues, then again you have to sue through the trademark owner, because if you go to court, and we'll be talking about some of these issues in the next parts now, who are the necessary parties to the suit. So let's say McDonald's USA, and they are the franchisor, and they give you the franchise operation to run in Estonia, so you're the franchisee. And now you have this arrangement and you're paying McDonald's a ton of money and all that stuff. But it's attracting customers and easy publicity, and you don't have to go about proving yourself. You get straight into the market, you have the money, you start making more money. That's business. Now let's say somebody else opens up a McDonald's in Old Town. Yeah, what the hell? And so now you are upset and you go to that person and say, who the hell are you? I'm the original McDonald's franchisee. And so that other person says, well, yeah, my girlfriend's grandfather's best friend's name was McDonald. Yeah, so I'm starting this business in his honor. Do whatever you want to do. So what could you do here? Can I go and file a lawsuit as a franchisee on my own and try to prevent somebody else from using the McDonald's trademark? Well, the first question the court will ask me is, who am I and what's my relationship with the trademark, and am I the owner of the trademark? If I'm not the owner, then then just shut up and get out, right? I mean, you have to bring in the owner of the trademark, because you can't just file a lawsuit on your own name. And so these are some of the issues that come up, of course, and we'll be talking about this in more detail. So as you can see, yeah, even from the notes, this is something to be careful about. Okay, so now that we have spoken about this issue, just one last bit would be, when you have a trademark and you have applied for registration of the trademark, but it's not registered yet, you put in TM at the end of the trademark. Yeah, so your trademark may be Viagra or whatever, and you put TM, and now after it gets registered, you put R in a circle. Now, this is more of a local legislation thing. You may not find much about this in the directive, because the directive doesn't deal with all these sort of silly things. But it's very important, because if your trademark is R in a circle, it is a registered trademark. You can file a lawsuit for infringement and you can prevent others from using your trademark. But if your trademark is just a TM, then you have restricted rights, because you've applied for registration. You're not the owner of the trademark as such, in a registered sense. So let's talk about infringement and passing off now. And this is, of course, the main legal part. As a lawyer, all of this, whatever we've been studying, is just mumbo jumbo. All right. I mean, end of the day, it's what you do in a court of law. Can you go to the court and can you get an order in your favor, or your client's favor? If not, then all of this is just theoretical nonsense, which has no relevance in real life. So, well, if you are a real lawyer, you should have some experience in a court of law. And even if you don't plan to practice as a lawyer later on after your law studies, maybe you just want to work in a government office or in a company or whatever, fine. I'm not saying don't do that, but go, please. From my own personal experience, I can tell you, you should go and work in a law firm, even if it's for a year or 2 years. You never know. Uh, um, and well, you can always change your mind and stay in the legal profession, and make a mark for yourself, or then you can always go and work anywhere else. But at least have a law background, and going to a court and going before a judge and getting hammered by a judge, and getting in all sorts of troubles, and thinking on your feet and coming up with quick solutions, keeping your clients happy, and staying legally within the limits of your profession. All of these are things that can only come from experience, not from reading a book or something. So we have trademarks directive, and we are now going to talk about the rights conferred by a registered trademark. So of course these rights are, you have certain rights, and so these would imply that you can do certain things. So what are your rights with a trademark? Just to sort of hold on a second. Okay, so we are now here, lecture 5, notes in Moodle. Yeah, it's a bit confusing, I guess. It's got all sorts of things going on. There are these lecture notes, and then there are the video lectures and everything. So rights conferred and limitations. So rights conferred are under Article 10. Yeah, and so the registered trademark or the registration of a trademark shall confer on the proprietor exclusive rights therein. And then of course, yeah, so I can read more about Article 10 over there, and what is allowed and what is not allowed. So the key aspect over here from a legal viewpoint is, of course, the registration of a trademark. So your trademark has to be registered. Only then you can go to a court of law and file a lawsuit for infringement. If it's not registered, it cannot be a lawsuit for infringement. Then there are other ways. So we can talk about those later on as well. And well, what are the rights? So of course, shall be entitled without prejudice to the rights of proprietors acquired before the filing date or the priority date of the registered trademark. The proprietor of that registered trademark shall be entitled to prevent all third parties not having his consent from using in the course of trade in relation to goods or services any sign where sign is identical or similar, or it's a well-known trademark. So those requirements are there, and you will see that these are quite similar to what we had spoken about previously, about grounds for registration of a trademark. Remember, we spoke about a trademark which is identical, or a sign which is identical, or a sign which is similar, and then we're talking about whether it is similar, not similar, in regard to well-known trademarks. And so those things covered as well. But let's talk more about practical things. You can always read whatever is there in the notes. um, so how would you file a lawsuit? What are the procedures for it? So let's say, first of all, there's a trademark, and your trademark is Viagra. So you represent Pfizer, and now you come across somebody who is selling a medical product called Viagreen. All right, and it's your Viagra tablet is blue in color. It's a scheduled drug for impotency in men, and then of course it has you need a medical prescription for it, and it's not something that you just take with vodka or whatever. So that's your trademark, and now somebody is selling a medical product which they claim doesn't cure impotency, but just sort of makes you I don't know, horny or whatever. Yeah, whatever it is. So it's sort of similar in a way. Yeah, it's like a placebo effect, but it's just a mixer. You drink it, and this is a real life case. So what would you do? Well, as a lawyer for Pfizer, first of all, you would find out that okay, this is a problem, and then you would send a legal notice to the other side, and tell them that you are the owner of the trademark, you as in your client, and that you have been doing the business, and now your marketing or sales team has come to know that the other side is selling this product which is similar somehow to our client's product, my client's product, and so you want them to stop doing this. That's the first stage, of course. And then they reply back and they say no, or yes, or whatever. So that's their reply. Now, based on that, you would then file a plaint, and the plaint would have to have all the necessary parties to the suit. As I said, earlier, with a license, for example, you have to bring in the licensor, the licensee, everybody. And if somebody doesn't want to come, then you can always make them a pro forma defendant. You don't claim against them, but they are necessary parties to the suit. So in the plaint or the suit or whatever, in an appropriate court, jurisdiction wise and everything, you would say that you're the owner of the trademark. And of course, jurisdiction can be a bit tricky. It could mean you have to file the lawsuit where the defendant is based. So there are all of these aspects to keep in mind. And which court do you go to? And of course, this is a civil law dispute, all right? So not a criminal law dispute. So you would then say that you're the owner of the trademark. This is your registration. These are your sales. This is what you've been doing. All these countries, 100 countries, etc., etc., etc. And then you would say that you came to know that this person, other side, was misusing the trademark, and so you have sent a legal notice, and now you have explained to them your trademark is Viagra and their trademark is Viagreen. So the initial parts are similar, identical, and it's blue in color, and of course, it's for a similar purpose. Although yours is a scheduled drug, it is not easily available except on prescription, and theirs is a mixer. But you could say that the chances are that people may think that, just like for children, you have Sudafed or something like that, for fever, and it's 500 milligrams. But for a child, you can have a liquid version of it, and it comes in a bottle, and you can just pour it and give it to the child. So you could say that there's a risk of confusion because people may think that Viagreen is a softer version of Viagra, the alcohol version. So of course, you can make up all of these, and then you have sent a notice and the reply, and now your counter reply, and nothing is happening. And so basically, that's the story. And the main thing are the claims. What do you claim? What do you want as a plaintiff? So, well, you want certain things. For example, you want this court to declare that yes, this is an infringement of a trademark. Number two, you want the court to, get you an apology from the defendant for misusing the trademark and causing you harm and damage. Number three, you also want, well, you want compensation, of course. So how much compensation, depending on various things. You don't say 300 million because that number also depends on how much you have to pay to the court as court fees. So, you have to be a bit careful about these things. Be realistic. Then also that you want all the already prepared drugs or Viagreen product or infringing product to be destroyed, and the packaging to be destroyed, either through a court person or delivered to you for destruction, and that this person, the defendant, will never again infringe your product. And these are of course long term things. The lawsuit may take 4 years, may take 3 years. In the meantime, you also want um, temporary injunction, not just a permanent injunction, but you want something temporary as a relief. So you say that while the court decides all of this, the defendant should be stopped from using this trademark and stuff. And so and of course deliver all the products, put them in suspension, put them in a go down or a warehouse, and deposit some money as potential fine or damages and things like that. So that would be your entire plaint. Now, of course, you could have sometimes more complicated issues, and these can arise in a different form. So, for example, there was this one lawsuit I was involved in, and the problem was that our client, Unilever, they made this soap bar, like a proper solid soap, and you could use it to take a shower or whatever. And well, so they were selling it under the trademark Lux. And then there was this economic crisis, 2008 2009, in Southeast Asia. So from Singapore, Malaysia, Indonesia, the same product, better quality, was coming to India, and was selling in the market. So the same soap with the same brand but made in a different country comes to India, and it's made by a Unilever subsidiary, so it's not like a fake product. This is now a more problematic area. It's exhaustion of trademarks. If you read the article and the information I put up on exhaustion, for example, you will see a lot of stuff that arises in this regard, and this is a real nightmare. Have I put up here? Oh yeah, that's your homework, right? Exhaustion of trademarks. Of course, that's a huge area. So now the problem here is, well, as the lecture said, what's basically happening here is prevent all third parties not having the consent of the proprietor from using in the course of trade in relation to goods or services. So all of this plays a role here, and so now we wanted to stop all this fancy, better quality product of a sister company of the same group of companies coming into India. So we are now trying to say that we are the owner of the trademark Lux, which is registered in India. So that's an Indian trademark. And this foreign product, which comes from Singapore, is a Lux also, yes, but it's a Singapore trademark. And very often, if you see on the packaging, it says not for sale outside EU or not for sale, whatever. So this is a huge problem area because this is not straightforward. All right. Basically, when you talk about not having consent, you're talking about exhaustion in the international sense, and national sense. And if you read the stuff I sent to you, or I put up in Moodle on exhaustion, it's even more crazy because inside the EU there's a different rule, outside the EU there's a different rule, and so this is a huge area. Usually I talk about this under competition law and IP because it's a huge topic, and I believe this will restart as a course for master students from the next academic year. Yeah. So again, you can do this sort of stuff. Now the issue here was that this stuff is coming to Bombay. Bombay is a port. So, or Calcutta is a port, or Chennai is a port, and so obviously it's coming by ship, all right, and not coming by air. So now you know how it's coming. It's coming in a container, two containers, a million pieces of soap, and so you have to now find out, or we had to find out through the customs people and the manifest as to what comes from where. Now, because the importers were just small time parties, they just buy 40,000 pieces of soap, and they get it from Singapore, let's say for €1 per soap, let's imagine, or €2 per soap, and because it's a sale because of the economic crisis, and now they put it on a container and it costs, let's say, €1,000 to get from Singapore to Bombay, presume, all right. I'm sure it's a bit cheaper than that. And now in Bombay you can sell this same product for €4, yeah, let's imagine, and the local product that is sold by the Indian company sells for €4.5. You see the maths over here. You're picking up something for €2 from Singapore and you can sell it for €4 in India, and so you're making a profit over here even after you calculate the transportation costs, and it's still cheaper than the local product because of various reasons. So in this situation, time is of the essence, and so you don't have the luxury of sending a legal notice to the other side. So now you want the court to grant an injunction, temporary injunction or whatever, ex parte, without both parties to the suit being present in a court of law. And you're doing this because there's urgency, that there is real risk of economic damage, and that if something goes wrong, of course you promise to reimburse everybody. So again, complications that come up. Now, it's not always just the civil law side that you can deal with, but you can also file a criminal lawsuit. Infringement of a trademark or IPR is also a criminal offense under the criminal law of the country. And now this may not be in the directive because directive doesn't deal with criminal laws. Criminal laws in the European Union are not as yet completely harmonized. Yeah, again, problems come out. So again, from experience, well, so we were the lawyers for Pfizer, yeah, and what was happening was that in London, yeah, fake Viagra was being sold in pubs and discos and bars, and people were just buying them and just drinking them with beer or something, and no joy. It wasn't working because it's made of chalk and it's some fake product. So Scotland Yard of the UK got involved in this, and they came to know that fake products are coming. So Pfizer was involved. Pfizer is an American company, so the FBI was involved, and this turned out to be a huge international drug racket. And so they found out through their sources that the shipments were coming from India, and finally they were able to pinpoint which part of India where they suspected the factory or the warehouses were. All right. So this is police job, and they do all this criminal intelligence units and everything. So now the question comes up here is, what do you do? Well, Pfizer wanted to file a criminal complaint. Criminal complaint is not everybody's cup of tea, all right. Cops have have better things to do. There's terrorism, there are bombings, there is Al Qaeda, ISIS, all sorts of weird stuff going on. people are getting murdered, raped, and heroin and LSD and real drugs are being sold. And now here comes a lawyer and says fake Viagra is being sold in UK pubs, and it's coming from this particular part of India called Pondicherry. Yeah, the cops are going to be like, come on. I mean, we have better things to do. So of course, but Pfizer said no, we have to file a criminal complaint. And so you have Scotland Yard, you have FBI, and then in the Indian federal agencies, so they have this CBI, Central Bureau of Investigation. So they got involved. Then the local cops had to be involved, and now you have to pinpoint and figure out what is a good time to conduct a police raid on the premises of this factory. And of course, the police are not just sitting there waiting for you, they have other things to do, so you have to now coordinate with them and things. And this can cause a lot of problems because criminal law is very fascinating and has a lot of amazing things. I really enjoyed this part because you work with the police, you see the criminal mind and how some people do things, but of course there's a lot of danger also involved in this. And so finally the raids were conducted and nothing came out. The warehouse was empty, there was no factory. And then started the blame game that, oh, Indian police is corrupt, and so they gave out the information to the drug dealers. And the cops are like, no, you told us. So maybe the FBI is corrupt, or maybe somebody in Scotland Yard tipped off somebody in London. So you see how all of this goes. It takes you out of your comfort zone. You're dealing with criminals, you're dealing with government agencies, you're dealing with cops, people who don't understand why you are so upset about trademark infringement and some stupid fake Viagra tablets which haven't killed anybody or which have not hurt anybody. So you see, but again, of course, what I'm trying to impress upon you is that you can go through the civil route or the criminal law route, and both are feasible. So, well, that would be, of course, Article 10, Article 11, Article 12, Article 13. And so what's important over here is consent. Article 13, Article 12 is, of course, reproduction in in an encyclopedia book, and what can you do about that. So these are articles 10 to let's see, 11 is about preparatory aspects. So if you are not selling the product but you're a packager, or you're the manager of Stockman, and fake products, fake Gucci or fake Louis Vuitton bags are being sold in Stockman, then of course again you are responsible. You're the courier company, you get the shipment from Hong Kong and now you take it to Helsinki, and so you're just dealing with the courier package and you have no idea what's inside. Well, again, that's a problem because the law is quite wide to cover all of these issues and areas. So these are covered here. Articles 10 to 13, you can read more about them, and the examples are all similar to what we had discussed in what is a good trademark. Remember when we spoke about absolute grounds and relative grounds? So many of these are covered over here. And then there are well-known trademarks, very controversial. The simplest one was there's Victoria's Secret, and then somebody came out and had a shop in which he was selling Victor's Little Secret, $1, cheap lingerie, or pens, and you press the pen and then the man or woman becomes naked or whatever. And so somebody complained to Victoria's Secret and said, hey, I buy stuff for my wife from you and expensive lingerie, and now there's somebody selling Victor's Little Secret stuff. And so Victoria's Secret, of course, sued Victor, and they won in the district court, they won in the federal court, but Victor went to the Supreme Court, and the Supreme Court said under the US law at that time, you have to prove not only that infringement has occurred, but that actual damage has taken place. So they had to prove that somebody actually believed that Victor's Little Secret $1 bra was, tempting enough for them to think that it's actually from Victoria's Secret. So you see, a lot of this stuff comes up with well-known trademarks, and you can read more about it, of course, in the notes. Um, and consent, whether you have consent, is it legal consent, implied consent or express consent. We have spoken about this as well. So there's a lot of repetition that comes up over here. Of course, in Victoria's Secret, they got the law changed in the US. Yeah, so now, of course, it's no longer applicable. And then there was this Merc case, and so somebody was selling white cotton T-shirts with Merc written on it, MERC, and would you actually believe that a $5, $10, €7 white T-shirt with the word Merc on it is made in Germany and belongs to the Mercedes company? No, of course not. So you see, trademarks which are well known are not always that easy to prove or disprove. And again, you have to be able to show what are the similarities. You cannot compare the trademark side by side. You have to refer to a person, common person, average intelligence, imperfect recollection. So all of these are important elements to keep in mind. And then there are, of course, defenses. As a defendant, you can always say, well, first of all, you have the consent. Remember, the law said without consent, so I have the consent. How do you prove that? Well, I'm a licensee, I'm a franchisee. Of course, we have your agreement, and you told me I can use the trademark McDonald's. And now you're saying that this agreement is no longer valid, but I'm saying it's valid. It's not been properly cancelled. Again, legal stuff. Or that it is genuine, as I explained in the Lux case. So this is, of course, exhaustion, and you'll read more about that for your homework. So that will really take care of that part. Or you can just attack the registration itself and say, you're acting smart because your trademark is registered, and that's why you're filing a lawsuit for infringement, right? So I'm going to get your trademark deregistered. Yeah, offense is the best form of defense. Or, of course, you have independent right. The plaintiff did not use the trademark for 5 successive years, or plaintiff allowed you to misuse it, or whatever. And so these are the various grounds. Yeah, and based on these, of course, you can file lawsuit, and you can defend yourself and things. But what happens if the trademark is not registered? Then there is the action for passing off, which you can read in the notes, and it's under tort law. So basically, it's a civil wrong not arising out of contractual duties, for which the only appropriate remedy is a suit for damages. In the German context, it's also known as an unfair trade practice. So it's quite common in that sense. And there are certain main laws, case laws here in the UK under English law, the Advocat case, and then the Jif Lemon case. Now, basically, you see, the problem here is that you have to keep in mind, if your trademark is registered, you have a certificate, you go to the court will not question how, why your trademark was registered. Is it registrable? None of that. If your trademark is not registered, first you have to prove to the court that you have a good case, that your trademark is worthy of being protected, even though for some reason it's not registered. And then you have to prove that the other side is doing something wrong. Yeah, and this is very complicated, because the court will ask you, hey, if your trademark is so good, how come it's not registered? Yeah, yeah, simple question. So there are these two cases, Advocat and Jif Lemon. Read them. That's the real only way to understand how this law works. It's complicated. It's not infringement. All right. So let's stop here for today. And thank you for your time. We start with patents next time. Okay. So goodbye.